Welcome to our deep dive into the right of private defense under sections 34 to 44. This video will guide you through the legal framework, limitations, and real-life cases that shape the understanding of justifiable defenses. We'll explore how the law recognizes the need for self-protection, the boundaries set by statutes, and the practical implications for individuals facing threats. By the end, you'll have a clear grasp of when and how private defense can be lawfully exercised, and why it's crucial for maintaining justice and safety in society. Section 34 provides statutory recognition to the right of private defense, affirming that nothing is an offense when done in exercise of this right. However, there are two key limitations. First, actions that are strictly offenses cannot be justified as private defense. Second, an attacker cannot claim this right if they provoke the attack themselves. This ensures that the law protects only genuine acts of self-defense, not retaliatory or aggressive behavior. The principle is rooted in the idea that society cannot have a watchdog for every wrongdoing, making self-defense a necessary safeguard. In Lakshman Sahu versus State of Odisha 1988, the court clarified that the right of private defense is available only to those suddenly confronted with immediate necessity to avert impending danger not of their own creation. The need must be present, real, and apparent. This means that the right is preventive, not punitive, and can only be exercised to repel unlawful aggression, not to retaliate. The law aims to protect individuals from unexpected threats, ensuring that self-defense is used responsibly and only when truly necessary. State of Uttar Pradesh versus Pussu 1983 case established that a person who is an aggressor and seeks attack on himself by his own aggressive actions cannot rely upon private defense. This principle prevents misuse of the law by those who provoke violence and then claim self-defense. The right of private defense is strictly reserved for those who are genuinely threatened, not for those who instigate conflict. This distinction is vital for maintaining fairness and preventing abuse of legal protections. Shukla versus State of Madhya Pradesh 1992 emphasized that the right of private defense is preventive, not punitive. The law allows individuals to protect themselves or their property, but not to punish aggressors. This ensures that self-defense remains a tool for safety, not for retribution. The distinction between prevention and punishment is crucial, as it maintains the integrity of the legal system and prevents escalation of violence. Singh versus State of Punjab clarified that the law does not require a person facing assault to run away to a police station, instead of protecting themselves or their property. The right of private defense empowers individuals to act in the moment to safeguard their well-being. This practical approach acknowledges the realities of sudden threats and supports the principle that self-defense is a fundamental right. In Dwarka versus State of UP, the court held that private defense is not available in cases of free fights between two groups. This limitation ensures that the right of private defense is not misused during mutual conflicts, where both parties are equally aggressive. The law distinguishes between genuine self-defense and situations where violence is reciprocal, maintaining fairness and preventing chaos. Hami versus State of Madhya Pradesh 1998 clarified that there is no right of private defense against an act of self-defense. This means that if someone acts in self-defense, others cannot claim private defense against that act. The law carefully separates genuine self-defense from retaliatory actions, ensuring that only those truly threatened can invoke this right. Section 35 deals with the right of private defense of both body and property. This right extends not only to one's own person and property, but also to those of others. Every person in India has the right to defend their own body, and the body of any other person against offences affecting the human body, as well as the property, movable or immovable, of themselves or others against theft, robbery, mischief, or criminal trespass. The law recognizes the importance of protecting both personal safety and property rights. Accused pleading the right of private defense is not required to call evidence. They can establish their plea by reference to circumstances transpiring from prosecution evidence itself. This legal provision simplifies the process for those genuinely acting in self-defense, making it easier to prove their case and ensuring that justice is accessible. Section 36 addresses the right of private defense against acts committed by persons of unsound mind. The principle is that the right does not depend on the actual criminality of the aggressor, but on the wrongful character of the act attempted. Even if the aggressor is a youth, mad, or intoxicated, the person threatened has the same right of private defense as against a sane person. This ensures that the law protects everyone from wrongful acts, regardless of the aggressor's mental state. Section 37 lays down the limits within which the right of private defense should be exercised. There is no right of private defense against acts done by a public servant if certain conditions are fulfilled, such as the act being done in good faith and under the colour of office. The law presumes public servants act in conformity with the law and protects them in the execution of their duty, even if they err. This restriction maintains order and trust in public authorities. Right of private defense against injury by a public servant extends only to cases where there is a reasonable apprehension of death or grievous hurt. The law uses the phrase, not strictly justifiable by law, to indicate that even if an act is not strictly legal, it may still deprive a person of the right of private defense if done by a public servant. This nuanced approach balances individual rights with public authority. Clause 3 of Section 37 states that no person has the right to take the law into their own hands for protection if there is a reasonable opportunity for redress by recourse to public authorities. However, if the attack is sudden, unpremeditated, or help is unavailable, one can exercise the right of private defense. This ensures that self-defense is used only when necessary and not as a substitute for legal remedies. Clause 4 of Section 37 emphasizes that the harm caused in self-defense should not exceed what is necessary for defense. The right is to defend, not to punish. This principle keeps self-defense within reasonable limits and prevents excessive force. The law requires that the measure of self-defense must always be proportionate to the quantum of force used by the attacker. Classic example of justifiable harm is when A, finding a thief entering his house at night, seizes him and holds him down to prevent further entrance, causing the thief's death by suffocation. This act was deemed justifiable as it was necessary to prevent the crime. The law recognizes the need for decisive action in the face of immediate danger, but always within reasonable limits. In contrast, excessive harm is illustrated by a case where a thief was caught at night and struck with a pole 5 times on the neck, resulting in death. The accused was convicted of culpable homicide not amounting to murder because more harm was done than necessary. This underscores the importance of proportionality in self-defense actions. Section 38 authorizes a person under reasonable apprehension of danger to inflict death upon their assailant. The apprehension must be real, not imaginary. The right extends to causing death only when the offense is of a kind mentioned in this section. For example, unreasonable fears, such as those related to witchcraft, do not justify lethal self-defense unless physical violence is genuinely apprehended. Section 39 allows any harm short of death to be inflicted in exercise of the right of private defense of body, provided the limits of Section 37 are not violated. This means that injuries can be justified if they are necessary for defense, but not if they exceed what is required. The law balances the need for protection with the prevention of unnecessary violence. Section 40 states that no actual injury needs to be received before the right of private defense is exercised. The law acknowledges that the threat itself is sufficient to justify self-defense, allowing individuals to act preemptively to protect themselves or their property. This proactive approach enhances safety and prevents harm. Section 41 addresses when the right of private defense of property extends to causing death. If a person enters a house at night with intent to commit theft, only harm short of death is justified unless there is a real danger of death or grievous hurt to the defender. The law distinguishes between different types of trespass and the level of force permitted, ensuring proportionality and justice. Law differentiates between house trespass and open land trespass. Only house trespass under circumstances causing reasonable apprehension of death or grievous hurt is enumerated as an offense under Section 41. Open land trespass does not justify causing death. This distinction protects property rights while preventing excessive force in less dangerous situations. After the 1970 amendment in IPC, mischief by fire or explosive substance committed on government property, railway property, or transport vehicles is included under Section 103 by Karnataka, Maharashtra, and Uttar Pradesh. This expansion reflects the evolving needs of society and the importance of protecting public assets from criminal acts. Section 42 justifies causing any harm short of death in exercise of the right of private defense of property if the offense committed or attempted is theft, mischief, or criminal trespass. The law allows defenders to act decisively to protect property, but always within the bounds of proportionality and necessity. If a trespasser enters a house with intent to commit theft and is attacked by the owner, the trespasser cannot claim the right of private defense. Acts that give rise to offenses cannot be treated as a basis for the exercise of private defense in favor of the offender. This principle ensures that only lawful actions are protected. Section 43 states that the right of private defense of property commences when a reasonable apprehension of danger arises. Actual harm is not necessary, the threat alone is sufficient. This allows individuals to act before their property is actually harmed, enhancing protection and preventing loss. Under Sections 40 and 43, the right of private defense commences as soon as reasonable apprehension of danger to body or property arises from an attempt or threat to commit an offense. The law does not require waiting until harm is done, allowing for timely and effective self-defense. Section 44 covers the right of private defense against deadly assault when there is risk of harm to innocent persons. This section applies only when there is reasonable apprehension of death, not lesser harm. It justifies causing harm to innocent persons if necessary to protect oneself from deadly threats, reflecting the complexity of real-life situations. Illustration of Section 44 is when he is attacked by a mob attempting to murder him. If he cannot exercise his right of private defense without firing on the mob and risks harming innocent children mingled with the mob, he commits no offense if harm occurs to the children. The law recognizes the tragic necessity in extreme situations, balancing self-defense with unintended consequences. The concept of private defense is rooted in the idea that individuals must be able to protect themselves and their property when faced with unlawful aggression. The law provides clear boundaries, ensuring that self-defense is exercised responsibly and only when necessary. This foundational principle supports justice, safety, and the rule of law in society. Reasonable apprehension is a key concept in the right of private defense. The law requires that the threat must be real and apparent, not imaginary or exaggerated. This ensures that self-defense is invoked only in genuine situations, preventing misuse and maintaining fairness. Proportionality is central to the law of private defense. The harm caused in self-defense must not exceed what is necessary to repel the threat. This principle prevents excessive force and ensures that self-defense remains a tool for protection, not for punishment or escalation. The right of private defense extends not only to one's own body and property, but also to those of others. This collective protection strengthens social bonds and ensures that everyone has the right to intervene when others are threatened, fostering a safer community. Law limits the right of private defense against acts by public servants, provided the acts are done in good faith and under the color of office. This preserves trust in public authorities and ensures that self-defense is not used to undermine lawful actions by officials. The right of private defense commences with reasonable apprehension of danger, not actual harm. This proactive stance allows individuals to act before suffering injury or loss, enhancing safety and preventing crime. The law recognizes the right of private defense against acts committed by persons of unsound mind, youth, or intoxicated individuals. The focus is on the wrongful act, not the mental state of the aggressor, ensuring equal protection for all. Section 44 justifies causing harm to innocent persons in extreme cases where self-defense against deadly assault is necessary. The law acknowledges the tragic reality that sometimes protecting oneself may inadvertently harm others and provides legal protection in such situations. The law distinguishes between defense and retaliation. Private defense is preventive, aimed at repelling unlawful aggression, not punishing the aggressor. This distinction maintains the integrity of self-defense and prevents escalation. Private defense is not available in cases of free fights between groups. The law ensures that mutual aggression does not qualify for self-defense, maintaining fairness and preventing abuse. There is no right of private defense against an act of self-defense. The law separates genuine self-defense from retaliatory actions, ensuring clarity and preventing confusion in legal proceedings. The right of private defense of property covers both movable and immovable assets. Individuals can protect their property from theft, robbery, mischief, or criminal trespass, ensuring security and upholding property rights. State amendments, such as those in Karnataka, Maharashtra, and Uttar Pradesh, expand the scope of private defense to include mischief by fire or explosives on public assets. This reflects the dynamic nature of law and its adaptation to societal needs. The process for establishing a defense plea is streamlined, allowing accused individuals to reference prosecution evidence rather than calling extra witnesses. This makes justice more accessible and supports genuine self-defense claims. The law justifies causing harm short of death in defense of property or body, provided the harm is necessary and within legal limits. This ensures that defenders can act decisively without crossing boundaries. In summary, the right of private defense is a vital legal safeguard, carefully defined and limited to prevent misuse. The law provides protection for individuals and property, sets clear boundaries, and adapts to societal needs. Understanding these principles ensures responsible exercise of self-defense and upholds justice. By knowing your rights and their limits, you contribute to a safer and fairer society.